Hello and welcome to Juris Edge Academy's YouTube channel. आज के वीडियो में we will be talking about the family law previous year questions from CLAT PG 2020 to 2022 paper. तो अगर आपको पता हो कि CLAT PG का पेपर 2020 में drastically change हुआ था and this is why it is very important if you're going to appear for this exam then you need to look at the previous year paper starting from 2020 onward. So in this video we are going to be covering the papers of 2020, 2021 and 2022. Since in 2023, no family law questions were asked, so we have only covered these years. So let's first start with the CLAT PG 2022 question paper to understand what kind of questions have been asked in this paper. So the paragraph is displayed on your screen. So this paragraph was given as the first passage in which they were talking about the concept of maintenance under the family laws. So the first question on this passage was that based on this judgment, which of the following judgment is related to enforcement of orders of maintenance. So in 2021, a very landmark judgment in Rajneesh versus Neha has come, and this is the judgment which they are talking about. Now coming to the next question was that under the Hindu Marriage Act, which of the following reliefs are provided for? So the correct option is option A, because Hindu Marriage Act provides for all of these things, which is maintenance, pending litigation, expense of proceedings, permanent alimony, as well as maintenance. The other three options are incorrect because they do not fully incorporate the understanding of HMA. The next question is that which of the following statutes does not contain provisions relating to maintenance? So the correct answer was option D, Muslim Women Protection of Rights on Divorce Act 2019. So this law was enacted to criminalize the practice of triple talaq after the Shaira Banu judgment. So the above three laws actually deal with the concept of maintenance. So the right answer is option D. Now coming to the next question was that which of the following was not a direction by the court in the judgment of Rajneesh versus Neha. So option C was not the direction because option C says that it is not mandatory for the applicant to disclose what maintenance they have received in previous proceedings, whereas in Rajneesh versus Neha, this disclosure was made mandatory. So option C is the right answer. The next question was that which of the following is not correct as per section 125 of CRPC. So they were testing your knowledge of 125. So the correct option was option D, that as per the explanation, wife does not include a woman who has been divorced, etc., etc. So these women are covered under 125, and that is why option D is the incorrect answer. Then the last question from this passage was on the understanding of Hindu Adoptions and Maintenance Act, but the options were very close and there was no way to select only one correct answer from the four options because there was more than one correct answer, and that is why in the final answer key, CLAT had cancelled this question. So you can look at the options and see how there is more than one right answer for this particular question. Now coming to the second passage that was asked in the 2022 paper, this passage was from the Family Courts Act, so some understanding of the Procedure and Family Court Act was required to be known. The first question from this passage was that which of the following is not correct about the Family Courts Act. So four options were given, of which the last option was incorrect because the last option says that any person can be appointed as a judge of the family court after the attainment of 62 years of age. So this was an incorrect option, and that is why they were asking you for the incorrect option of Family Courts Act. So this was the right answer. Next question was that based on this following, which of the following judgment is related to the working of Family Courts Act? So a recent judgment has come then, which was the judgment of Aman Lohia versus Kiran Lohia. So that was the right answer. Coming to the next question was that based on the excerpt, which of the following was held by the Supreme Court in relation to Family Courts Act? So the right answer was that non-compliance of prescribed procedure and infraction from principles of natural justice is not a technical irregularity which can be overlooked. So this was the right answer. The next question was that the family court must adhere to the norms prescribed by the statutes with regard to the adjudication of matrimonial disputes and also to what other thing. So the other thing that the family courts are required to comply by is the fair procedure and natural justice principle. So the right answer was option B. Coming to the last two questions from this passage, the second question was that which of the following is not correct about the nature of proceedings of Family Court Act. So family court proceedings must not always be held in camera. They can be held in camera, but there's no requirement for all of them to be held in camera. So that is why option A was the right answer. Last question from this passage was that Family Courts Act does not apply to which of the following matters. So it applies to divorce, it applies to nikah, it applies to marriage under SMA. It does not apply to adoption under Hindu law, and that is why option D was the right answer. Now this was the paper of 2022 and there were 12 questions that were asked in family law. Now coming to the 2021 question paper, let's look at what questions were asked. So this is the passage that was given. This was on section 6 of the Hindu Succession Act because of the Vinita Sharma judgment, which has come that year. So that was important. So the first question was that which of the following judgment is not related to the property rights of a daughter. So the first three are related: Vinita Sharma, Dhanama versus Amar, Prakash versus Fulvati. The last judgment is not related to property rights. So that is the right answer. Next question was that based on this judgment, which of the following statement is not correct in relation to section 6 of HSA? So section 6 basically gave equal rights to a daughter, and option B says that daughter will not be subject to the same liabilities as the son. So that is the incorrect understanding, and that is why option B is the right answer. The next question was about the doctrine that the doctrine of legal fiction, which is created to ascertain the shares of the deceased in a joint property. What is the doctrine called? So the answer was doctrine of notional partition, and that is why option A is correct. Coming to the next question, they were asking that the judgment in Kiran Devi, which was again a recent case back then, what does it relate to? So the answer was presumption of Hindu joint family property, and that is why option C was the right answer. Next question was that as per the judgment, which of the following is correct in relation to the living status of the father? So this was actually the main reasoning of the Vinita Sharma judgment, which was that since the right in co-partnery to a daughter is by birth, it is not necessary for the father to be alive on the date in which this amendment came into picture. So that is why option D was the right answer. The last question was that which of the following judgment has held that a Hindu joint family is presumed to be joint in food, worship and estate? So the correct answer was Adivappa versus Bhimappa. Now coming to the next paragraph, which was asked in this 2021 year paper. So it was about guardianship. So the first question was that which of the following judgments upheld the constitutionality of section 6 of the Hindu Minority and Guardianship Act. So it's a landmark case of Geeta Hariharan versus RBI. So the right answer was option C. Next was that who is the natural guardian of a Hindu minor? The answer is D, that is father. Next was which of the judgment does not relate to the welfare of minor being of paramount consideration. So all the three options A, C and D are related to welfare of minor child. Only option B is not related to this concept. Next question was that who is the natural guardian of an adopted child? So the correct answer is adoptive father. Next question was which of the following is not correct regarding to parents patria jurisdiction. So parents patria jurisdiction ensures the welfare of its subject. So option C, which says that it is not to secure the welfare of the minor, is the incorrect understanding of parents patria, and that is why this is the correct answer. Next question was which of the following judgment relate to the concept of shared parenting. So again, a recent judgment has come in 2020, Yashita Sahu. So that is the right answer. Now coming to the CLAT PG 2020 question paper, in this particular year, 10 questions were asked from family law. So this was the paragraph which was given, which was relating to Shariat law, Muslim personal law, and the concept of talaq under it. So the first question was that what is the name of the judgment, which is quoted in the passage. So that was Shamim Ara versus State of UP. Second question was that which of the following legislations has been replaced by the second number in the passage. So the right answer was the Muslim Personal Law Shariat Act 1937. The third question was with respect to the understanding of Chief Justice Keher's opinion in the Shaira Bano case. So this was again based on the judgment understanding of Shaira Bano. So based on that understanding, option 1, 2 and 3 were correct. So you can look at your screens and see that these options were right. But the last option which said that majority verdict was given by Justice Nariman Lalit and Justice Chanchul, that is the incorrect option. Coming to the next question was about the different forms of talaq, and you had to find out which of the following is not correctly matched. So the 4 talaq options have been given with their description. You had to tell which of them is incorrect. So option 1 is incorrect, which incorrectly describes ihsan talaq in this option. Then the next question was that in which of the following cases proposition was laid down that personal laws are beyond the pale of fundamental rights. So this is a landmark understanding of the state of Bombay versus Narasu Appamali judgment. So option A is the right answer. Next question was with respect to what does res integra mean. So res integra means something, an issue which has not been decided by a law, by a judicial judgment yet. So option A is the right answer. Next question was with respect to a very landmark finding under family law. So the finding was that the constitutional law does not have place in family matters, and it will prove like a bull in a china shop. So this observation is very landmark, and it was made in the case of Harvinder Kaur versus Harminder Kaur. So the right answer is option A. Coming to the next question, they were asking which of the following statements is correct. So only option 1 and 3 are correct, because second option says that HMA does not recognize personal law and is a landmark legislation in the direction of UCC, which is incorrect. Fourth option is also incorrect because Hindu Marriage Act recognized widow marriages for first time in India is not right. Widow marriages were recognized beforehand. The last second question was with respect to the meaning of khula under the Muslim law. So khula is a right of women in Islam to take divorce, and that is why option A is the right answer. The last question from this passage was you had to select the right option. So first option is incorrect, that Muslim women cannot get divorced on ground of cruelty. They can, based on a 1939 law. Option C is also incorrect because Hindu women can get divorced on non-payment of maintenance for 2 years is not right. So option B is the right answer, which says that Hindu women can get divorced on conversion to any religion by her husband. Conversion by itself will not dissolve marriages of Muslim women. So these were the questions that were asked in the previous years in 2020, 2021 and 2022. Hope this has helped you. If you have any questions, you can comment them in the chat box. And if you like this video, please like and share and subscribe to our YouTube channel.